What's up, everybody, and happy Monday. We're here with another episode of The Lawyer You Know, and we are going to watch and react to a very interesting hearing in this Alex Murdaugh case. I'm really excited about today's episode because this hearing was really interesting to me, handling issues that do pop up from time to time in cases, but it's always interesting to hear good lawyering. And I think the lawyering on both sides of this case, I know some of you have your feelings about the defense lawyers, which is very common. It's a common theme in a lot of these heinous criminal defense cases, and this is a horrible one, as bad of facts as you can have in a case, and as despicable of actions from a lawyer that is supposed to be practicing a profession of ethics. But regardless of the facts, regardless of what you may think about the allegations against the defendant, I can respect good lawyering when I see it, and I think a lot of you can too. So this, in my opinion, is some good lawyering. The entire hearing was almost 2 hours long. We're going to play two main sections of it. The first is Alex Murdaugh's attorney explaining the blood spatter expert that the state has, how he came to his conclusion, how he may have changed his expert opinion, how he may have used some editing software, and how crazy some of this stuff is that actually happens pre-suit with government employees, government experts, that you would never believe if we didn't have open access to the courts. This happens. And we'll see if this expert ends up testifying, and you'll listen to the arguments made, but it's really interesting. And then I'll tell you what the prosecutor argues, but we don't need to watch that whole part because we are going to watch the prosecutor's main argument on his motion in limine to admit evidence. Now, the judge keeps saying this is kind of a reverse motion in limine. It must not be, happen often in South Carolina. It happens a lot in Florida, where we don't just file motions in limine to keep certain things out, but we do sometimes file a motion in limine if we think there's going to be an issue that we want to make sure we're able to argue, because we want to build our case around that. We want to build our opening statement, build our jury instructions, build our voir dire around it. And so the prosecutor in this case filed the motion in limine to get in to evidence of motive, which you'll hear is basically a bunch of terrible prior bad acts that they want to prove Alex Murdaugh did, which is going to make him look horrible in front of this jury. And the defense is arguing it's way more prejudicial than probative, but we're going to hear the prosecution walk through methodically all of the things they have against Alex Murdaugh. So if you haven't, take a second, hit that like button, subscribe to our page if you haven't already, and give us a follow on Instagram and Twitter here at Tragos Law, because I'm going to mention it here. We're going to talk more about it at the end. But if you're watching this video and you hit the subscribe button on my channel, or you're going to now, check out Crack in the Box. It's a new up-and-coming YouTube channel that may have a familiar face and a friend in common with a lot of you in this chat. So when this video is over, go check out Crack in the Box. We're going to talk a little bit more about it at the end of the video, but that's what we in the biz call a tease. Andrea Taylor, thanks for getting us started out right with this. And Andrea, if you can see, I thought it was over that shoulder, over this shoulder. This is so horrible because it's backwards, but you can see somebody sent me a nice bottle of wine today. Andrea had mentioned that she may send some nice adult refreshments that I may not enjoy, but a lot of my friends do. And I love hosting parties, especially on the holidays. So I appreciate you, Andrea, always being so generous and for reaching out and being so respectful. And absolutely is the answer. I enjoy it and appreciate everything you guys do and send. Lit Real Red is a new member. Welcome to the crew. Patrick Mott. Don't really know anything about this case, but happy Monday, Peter and Lawyer You Know fam. Hope you had a great weekend. Hit the like button, people. Patrick, let me just give you a quick synopsis. There's way too much background in this Murdaugh case for me to handle it right now. Check out our other videos, please, because we go into detail on some of these cases against him, and they're not going to hit all of them today, but the prosecutor gives you quite a peek into just a piece of what this former attorney is like. And at the end of the video, we're going to hear the judge give you an idea as to how deep-rooted the Murdaugh family is in South Carolina. This isn't just some guy. This isn't just some lawyer. It's going to affect the case at who this is, what family he's part of, and you'll hear why that's so crazy at the end of the hearing today. Mo, I got summoned for jury duty. Will my studies in criminal justice make me a bad candidate, and will watching be held against me? I really want to be a juror. I would say absolutely not. If you explain to them, and Mo, I don't know this about all of the people that watch or comment, but Mo comments enough for me to know. If you explain to them that you like this kind of stuff, you watch it on YouTube, and you've come down on both sides of every case. You listen to the evidence. You don't make up your mind beforehand. You can leave your biases at the door because you understand this case is only about this evidence and these facts. I think you'd be a great juror if you explain it like that, because I think that's how you are. You're going to give people the benefit of the doubt when you walk into the room, and each side's got to prove their case, or if it's a criminal defense case, the prosecution has to hold their burden. I think if you explain that, you'll get picked, and I would love to hear how your experience is if you do get picked for this jury. All right, without further ado, let's get to the hearing. It is on 1.5 speed. We're going to try to get this done in as close to an hour as possible. But we're starting out here with the blood spatter expert evidence and the problem that the defense rightfully has, in my opinion, with this prosecution expert.
To have this court have an evidentiary hearing on the so-called blood spatter evidence. And I want to walk the court through what we've pieced together.
P.S. As we've watched a lot of these Murdaugh hearings, the closed captioning is on. The sound is not great. It's pumped all the way up. So we'll do our best here, okay? So bear with me.
Concerning how this was done. And let me say this.
Because I read the motion,
we detailed that.
including the 11 pages of detailing
Yes,
all of that.
I think it's important, though, because when I asked for an evidentiary hearing, I think I want to emphasize something.
All right.
And I'm not going to walk you through the scientific tests that we know. What we do know is this, that on the night of the murder, they took from Mr. Murdaugh his shirt, his shorts, and his shoes. They ran a series of tests on those items and found a preliminary test indicating the presence of blood, and they cut out pieces and did DNA testing on those. There is some of the area which would become relevant as blood spatter is clear. Two things are clear. One is that one of those spots of blood spatter was negative for Paul Murdaugh's DNA. Number two, the test run by SWED, which we did not get until a couple, 3 weeks ago, indicated no presence of blood, of human blood, which if you're going to have somebody testify that there's blood spatter, I think part of that is there needs to be some blood. Now, critically,
Are you presuming that there will be testimony or the state will offer evidence of blood spatter, or you'll?
yes, sir. I mean, well, I would say that the state has indicated that pondering that based on evidence we've come forward with and the difficulty, and I just want to make sure for the record it's clear, that in the process of conducting these tests, SWED has destroyed the T-shirt for the purposes of examination. The way we became aware of that, let me say this, I want to make this clear.
So he's saying that when the expert first looked at it, there's no victim's blood on it, and there's no blood at all, theoretically, for them to test. And the way SLED, the investigators on the government side, the way they have done the testing on the shirt, now they've destroyed it. I don't think he means actually destroyed the shirt, but nobody else can do that same testing to have a competing expert, which is incredibly important, obviously, if we're going to have this argument about whether or not the blood is even that of the victims. He's going to say right here that he doesn't blame the prosecution at all. And this is actually a hearing I watched completely by myself, so I know what's coming. A lot of times we watch it together for the first time.
In no way am I inferring any untoward, illegal, unethical, dishonest conduct on the part of the Attorney General. I don't want that in any way to be inferred. I think he got those blood tests, the results of the blood test at the same time we got them, and we probably wouldn't have gotten them had he not asked to get all the reports through the attorney for SWED rather than going through the normal route. Since the shirt has been destroyed, we went out and looked at it. We all, Mr. Zelenka, Mr. Waters, and I all went out and looked at it, and they could see it can't be tested again. We wanted, and what key that was us wanting microscopic, I'm not talking electron microscope, I'm just sort of use a magnifying glass, basically to get the kind of photographs we wanted, that kind of detail. They couldn't do it, they can't do it, never will be able to do it. So as we looked at this further, Your Honor, we've done something in this case that most of it.
So that's what he means by destroyed, is no matter what you use, you can no longer analyze it the same way that SLED was able to when they found nothing of value.
Attorneys aren't able to or don't do. It's something we do routinely in a civil case, and that is to take the discovery and put it in a database, which is searchable. And in my office, Holly Miller, somebody right here, actually is a genius that knows that. I mean, I couldn't find. Let me just say, make this clear for the record. I in no way take any credit for using a database to find anything. That's way beyond my capabilities. But she found in something that was labeled a memorandum interview with Kenny Hughes.
So this associate or partner of his, another lawyer in his firm or employee of his firm, he's saying, we put all this stuff all the discovery into a database. It's common in civil cases. It doesn't happen often in criminal cases, I guess here. Sometimes does happen in our cases, especially in some big ones and some major ones. And he's saying that this employee searched through the discovery and found this very important, almost hidden memo to Mr. Hughes, who is the expert we're talking about today. So very interesting. And this is why good lawyering is important. Look through all the discovery, see what you have, master the evidence, be prepared because you may just find something like this.
The draft report of Mr. Bevel, their expert on blood spatter, in which he said there's no evidence of high velocity blood spatter. Not qualified. Now there's a PowerPoint that went with that. Apparently we haven't gotten it. We've asked for, but he was unequivocal, no blood spatter. And blood spatter.
So their expert in a memo said no blood spatter, and there's a PowerPoint that goes with it. They've asked for it, and that's what this hearing is about, in case you're wondering. What do we hear about? What is he asking for? He is asking for all of the evidence around this potential expert so that they can fight it with their own expert or ask the judge to completely throw it out because look at all this bogus stuff we've already found about this blood spatter expert. And the main thing is his first report is no blood spatter, and there is a PowerPoint, which is, you would assume, the PowerPoint explains exactly how he got to the conclusion that there is no blood spatter. And anything between you and your expert, that the reports that they produce is discoverable.
High velocity blood spatter is created when you're near somebody and you shoot them, and there's a sort of spray, very, very small spray. So once we had that, we began asking questions and looking at the report back from SWED. He was supported by that, by the DNA, which showed no Paul DNA in that area we're talking about. And then we began going back to the report we got from the Attorney General a few months ago of the final report by Mr. Bevel, who is, by the way, not a forensic chemist. He's not anyway got any scientific degree. He's a former police officer, and he looks at the patterns and determines what they are. And when we looked at that, he said, "Oh yeah, it's a blood spatter."
He's already, dismissing the expert's expertise.
So we then began looking at the SWED reports. What happened after they found out no blood spatter? Well, the chief officer in charge of this case, upon receiving that report, had a Zoom call with Mr. Bevel, and Mr. Bevel said, "Would you mail me the shirt, and so I can look at it and confirm it can't be tested further?" They said, "No, we'll bring it to you." He said, "No, all the time federal court, they just mail it, they do a secure mailing." And they had actually offered to mail things to him, mail the shirt to him earlier. That was their offer, not his request. But they felt it was necessary for two SLED officers to fly out there. And what Mr. Bevel does, according to what we pieced together, is and by the way, all they have is a picture of the shirt. That's all he had, a picture of the samples in the shirt. And again, this is outside my wheelhouse, photoshopped the shirt. His statement, photoshopped it to try to accentuate the little points. And in doing that,
It's never good to admit as an expert that you photoshopped a piece of evidence to come up with your conclusion. Now, there are situations where it makes sense, and you do need to do that, and that can aid in your expert opinion and your reporting and your testimony. But as a lawyer, as a defense lawyer, when you hear that, and I say that to you, let's just practice here, you all potential jurors out there. If an expert said he used Photoshop to enhance a photo of a picture to try to prove this blood spatter, and I said, Photoshop? You had to use Photoshop? What's your inclination going to be? Do you think, oh yeah, that's reasonable to use Photoshop? Or do you say, I don't know if I can believe this expert if he had to use Photoshop to come to his opinion? Let me know what you think.
I have an opinion. It was blood spatter. Now,
so after using Photoshop, he changed his opinion, and now it is blood spatter.
Your Honor, we're greatly concerned about what happened between the SLED agents and their so-called expert on that trip, and we have no emails. We have no communication between them. We don't know what they discussed. And by the way, there were other, based on what we read, we believe there are other versions of this report we have not received. So there are other versions, emails, communication. Did they record the Zoom call? I mean, we do that routinely. So we have a record of what this person said or that person said. In addition to that, I think it's telling that in this process of revising this report 180 degrees, that Mr. Bevel relied on this Photoshop process.
So he made a 180-degree turn on his prior opinion on this case. And I mean, that's just a dream argument for a lawyer, is what happened between your first opinion, which was bad for the government and good for us, to your second opinion that's now bad for us and good for the government, is you Photoshop the picture, right? I mean, it writes itself.
One of the things we have made a motion to file is a motion to compel the state to produce evidence regarding alteration of photographs of evidence it destroyed. In other words,
So that's what they're trying to do, is compel all of this discovery, including what Photoshop did you do? What did you change? How did you alter the evidence? How did you change your evidence? What was different in your PowerPoint when you found no blood spatter to the PowerPoint that you had blood spatter now? You can imagine the cross-examination of this expert witness as he's going through his argument and explaining all of the stuff that just sounds bogus, frankly, that this expert did.
They took these photographs. We can't photograph it. It's destroyed. They somehow, in the process of doing the blood test, and again, we've got a hematologist, an expert said, this is something that chemistry labs, crime labs do every day. In fact, they destroyed it. It's so unusual that it boggles their minds. This is something they do. They can't destroy it testing it for blood because we have a right to test it.
The shirt still exists. Or does it?
The shirt exists, but it is dark purple or black, and there's no way you can see detail of the threads. So it is.
Frankly, to me, that expert shouldn't be able to testify. If their testing destroyed it to where the defense experts could not test it, it shouldn't come in. And that's going to be an argument for a later date. But for right now, they just want this discovery. And Valerie asked, wouldn't no blood spatter be beneficial to them, though? I'm confused. Yes, that's the point, is the first initial opinion on the case by the expert is good for them. No blood spatter on their client's shirt. So if he was, I mean, it's a gruesome murder that was in close range, so he should have blood spatter. So if it's not blood spatter and it's not the victim's blood spatter, that's very good for the defense. But then the expert changed his opinion after photoshopping the evidence.
For forensic purposes, and I think the state is not going to argue you can test it. Mr. Bevel said you can't test it after he saw it, and the experts say you can't test it because it's been ruined. I mean, ruined for forensic purposes. It's whatever chemical treatment they put on it, they did wrong in the sense that it made it unusable after that. Now, Your Honor, so we made a motion to get, our first motion would be to compel the state to produce evidence regarding alteration of photographs of evidence is destroyed. And there's some very specific things on this Photoshop that we want the native Photoshop document that they created, used, and then manipulated. We have very specific things we'd like. They exist, and we'd like the state to prove them so that we can see. I mean, prior to this Photoshopping, his opinion was no blood spatter. Then he Photoshops it, and now it is blood spatter. Even though one of the points he finds on the shirt, he says now as part of the blood spatter, is negative, not negative. They exclude Paul Murdaugh as a contributor. So this becomes extremely important. The second thing that's important for us to do is have an evidentiary hearing where the select folks that conducted the test, the agents that went and met with Mr. Bevel, produce all their emails, produce all the communications.
He wants everything around this expert and around this blood spatter. He wants SLED, he wants the expert, he wants the emails, he wants the letters with everybody, and they deserve it and they should get it, especially since we already have this indication that issues arose.
Produce the Zoom if they have it, and any notes they have of those meetings. And if Mr. Bevel has notes of those meetings or emails or other communications, we'd like those too. I mean, Your Honor, this was leaked to the press a year ago that Al Murdaugh had Paul Murdaugh blood spatter was a shooter because he had blood spatter.
That is huge, and he's right, and that's what's up with these high-profile cases, and we've heard it time and time again. I'm not saying Alec Murdaugh didn't do this. I don't know. He's presumed innocent at this point. We'll see what comes out of trial, but the fact that they reported that Paul, his son's blood spatter was all over Alec's shirt, when in fact, it seems like there's not going to be a very reliable expert opinion of that, that's damning, and that's horrible. And if people walk in and think that before getting on this jury, that's really unfair to him in this case. People are going to know who he is, and they're going to know about this case, and we'll talk more about that later in the video.
First of all, SLED will testify there's no blood. So I don't know any have blood spatter. Number two, the DNA spot would exclude Paul. Exclude. And number three, we believe the forensics is going to show that whoever shot Paul Murdaugh and basically blew his head off would be covered in blood, not just spatter.
It's a little insensitive to say whoever shot him and basically blew his head off when you're talking about the guy's son who's sitting right there. And if you don't know, this is Alec Murdaugh right here, and he doesn't have a lot of, I don't know if you can see my pointer, but the full head of whitish, reddish hair sitting next to the female attorney is Alec Murdaugh. Not a lot of reaction when talking about this. If this was my son, I would not be able to contain myself if we were talking about things like this, but it's interesting to point out.
He stopped Mr. Bevel, wrote him a letter, said, here's the motions we filed. We'd like to talk to you. He got back to us yesterday. If I can hand you a copy. For Mr. Bevel, in which he indicated he'd be. I'm sorry, I'm not handing you the wrong. Let me see what I handed you. No, this is what I want to do. think I had two emails. Handed you the wrong one, Your Honor. Your Honor, what he says is, first, my apologies for not getting back to you sooner. We've been dealing with two deaths in our family, but we departed with many things on hold. Our company policy is always to honor a request to speak to an attorney about an active case. We always invite the opposing attorney to listen or be for the interview, and have done so in this case. I've not heard back from the possible date, but the available dates are identified. I assume you will allow us to talk to him and be present.
Absolutely, that's what we're told.
Okay. Secondly, Your Honor, we need an evidentiary hearing after we have a chance to talk to Mr. Bevel. We'd like to subpoena all these sway folks to come testify, but we'd like to get the documents from Mr. Bevel.
The purpose of the hearing would be what?
Pardon?
What's the purpose of the
The
hearing?
purpose of the hearing, Your Honor, is to develop a basis to determine whether or not we want to make a motion to exclude the shirt. Right now, we think there's lots of stuff here, but we need to understand, for instance, under
What's that case?
under the Chiefborough case, we not only have to show they destroyed the evidence or altered the evidence, we have to show it was done in bad faith. And that's why we need to ask what happened. Was it reckless? Was it beyond what's normal? What did they do wrong? And secondly, we can't develop that without talking to these folks at the minimum. And I'd like them under oath to be talked to. Also on the Photoshop piece, we need to understand how he did it. So we then can determine whether or not his, now that would be for a counsel hearing at a later date. I don't want a counsel hearing. I just need an evidentiary hearing to determine whether or not we have to hire additional experts.
You want this hearing, me to order them to produce information for us to then have another hearing so that you can then determine whether you can file a motion to exclude evidence at trial. Evidence that I don't know will be the state intends to offer.
Well, by then, hopefully we'll get it. I mean, I know that the Attorney General.
So the answer is yes. That is what they're looking for. That is what they want. They want to have all of the discovery, then they want to have another hearing. The state gets up, and one of their first arguments is, Judge, this is premature. We don't even know if we're going to call this guy as our expert witness. But then the defense responds with, we've got a trial in 5 weeks. We need to get this information, because if 3 weeks from now they tell us, yeah, we are going to call this expert witness, it's not going to be time for us to get all the information, have the hearing, fight this, try to get this evidence excluded. And they're 100% absolutely right, which is why we're going to get to the judge's ruling here. But I'm going to skip through some of the state's argument on this one, because we're going to hear the state argue a lot in a minute. 37.
That's the science, and to ultimately come up to whatever conclusion that is. They'll advise me of that. I'll advise the defense of that, as well as my decision. It may be that this
He's basically saying, just wait till we have our decision. Let the science take its time.
is not an issue.
Your Honor, two things. One, I believe they're obligated to give us whatever Mr. Bevel has. In addition, and I'm not sure that we got everything from them. And let me say this, we got some phone stuff. We got stuff last night, phone records that we asked for 3 months ago. We got a trial 5 weeks from now. And, I don't particularly want to be litigating this over the week before Christmas, the week after Christmas. We got work to do. So we'd ask Your Honor to order the state to provide us everything Mr. Bevel has, all his notes, any communications he has. Your Honor, let me put this in context for you. Mr. Bevel goes around the country testifying about blood spatter. He testified in Indiana, a case named CAN, C-A-N-N. The jury acquitted the man. He said definitely has a blood spatter of his wife and dead children on it. They did put, there's a national system to look for DNA, which they state then did. They have not done in this case. And they identified a guy named Boney, arrested him, and convicted him. But for some of the experts we've been talking to questioning Mr. Bevel's art and for it's not a science, that young man would have been convicted and doing life, going to the electric chair. So this is
They're also saying this expert has literally screwed up in the past, and people have been convicted based on his screw ups.
critical because this blood spatter, this guy's not a scientist. He looks at something and gives it sort of a Rorschach test. He had originally looked at it and said, nah, no blood spatter. Then he photoshops it and said, yeah, blood spatter. We need to understand why he changed his mind. And we'd like to, we need this evidence to get in a position. We're going to assume that he's going to go forward with it. But we can't wait until he makes a decision to get this information to begin working, to get ready for, maybe we won't have a hearing, but we need to be ready if we do. And we're 5 weeks out now.
Anything else on this motion? Yes, sir.
Very quickly, Your Honor, a couple things. Number one, I don't have custody or control of Mr. Bevel's notes. He's not a state actor. I do have, and we have provided.
Two things. There's a PowerPoint referred to in the original Bevel report that says no blood spatter. We don't have that. We have very specific information we want on the what you call it, he did of the blood spatter, the Photoshop. We need that for our experts to be able to analyze whether or not this is voodoo science or whether this is the real thing. And again, this is a guy who goes around the country doing this and has been wrong in the past. So we need that.
So I've heard enough on the issue.
Yeah.
Motions and what's at stake, and I reviewed your motion. Grant the motion to compel you to prepare a proposed order and share it with Mr. Waters, and I'll review it and issue a written order.
Thank you.
So he granted it. The state does have to turn over all this evidence, whether or not they've made their decision that they're going to call him. Now, if they say we're not calling him as an expert, we're not going to use this guy, then frankly, that's a win for the defense, and the state doesn't have to produce the discovery. But if they either are going to use him or are not going to tell the defense today, either way, they've got to produce all that discovery.
Thank you.
Next motion.
All right. So the next motion is just about a minute in, and it gets pretty wild here as the prosecutor goes through motive, as they're calling it, and why they want to use other bad act evidence. But real quick, rebel duck, find someone else to be an expert. That's a good point, and they could do that, except that they can no longer test the shirt because it is untestable because it was, for all intents and purposes, destroyed. Robo Steve, they need to have a hearing concerning the upcoming hearing on whether a hearing is needed. Welcome to litigation sometimes. It absolutely feels like this. And when you don't have a speedy trial like this and the court has 3 months before you can get hearing time, it is very, very miserable. Valerie, was this for life insurance? I might have to catch up on the details of the case. Just wait. You're going to hear whether or not there was a financial motivation to this murder.
Would have yesterday. And the reason for that is, Your Honor, is that in this particular case, where you have a man who was accused and indicted for the murder of his own wife and son, the motive might be the most important.
So here are the facts of the case and what the state believes the motive is behind these murders.
Fact that any jury would want to know. It's not an element of the defense, but it is the most important fact that any jury is going to want to know in this case. And for a jury to understand that, for them to really understand what the motive is in this particular case, they're going to have to understand that there was a huge difference between who Alec Murdaugh professed to be to the outside world and how important that was to him as a central figure in this prominent family, and who he really was, that only he knew, that no one else knew. Over and over again, I've interviewed witnesses, I put witnesses on the stand, and who thought that they knew this man, and they over and over again said, I didn't know him. I didn't know who this man was. And so for a jury to understand that, they're going to have to understand not only that distinction between who he professed to be and who he was, and how important that was to him, but also how that allowed him to avoid accountability for defrauding victims of almost $9 million since 2011 that we've been able to do. I think when this case started, a lot of people assumed that this was a murder case, and then a few months later, there was some white collar thrown in there. But the reality is we have done this extensive investigation, state grand jury investigation. We've realized that this is a white collar case that culminated with 2 murders. And so
this is a white collar case that culminated with 2 murders, meaning the murders were to cover up all of the other crimes. And there's a huge number of crimes that Alec Murdaugh is being charged with.
Look at the development of this particular case and the evidence in this particular case. What we see is that the defendant in the late 2000s, and that's a long time back, and I recognize that, Your Honor, but I think the important point to realize is that this is an unbroken chain of constant lies and misappropriations and thefts that has been going on for so long. A hamster wheel on which this man has been on constantly, having to borrow, to earn, to steal millions of dollars just to keep kicking the can down the road and staying above water, an exhausting hamster wheel. A slow burn that was heating up until June the 7th, 2021. And it all started with some land deals in 2008. 2007, 2008, the recession hit, and he really ended up upside down on those land deals, and it materially changed his financial picture. The reason why we know that, Your Honor, is that in early part of this past decade, in 2011, he had some big cases. He had the Pinky case, he had the Thomas case, he had the Badger case. And these cases, the people around him thought, they knew he had some issues and had some problems, but they thought that those recoveries and those really high fees that he had obtained, 6 figures or more, had fixed the financial problems that Alec Murdaugh had. But they didn't.
Being a lawyer is a crazy world, right? I mean, a lot of people know what we get paid or around what we get paid on cases, and lawyers like to act like big shots. I'm doing those Be a Lawyer shorts, and a lot of them are sarcastic or poking fun at lawyers, but there's so much ego at play. There's so much showboating. There's so much want to be the biggest, best, richest, slimiest, whatever you can be. And he's right. People in the outside world look at a family like Alec Murdaugh's and they just think, oh, they got to be making money hand over fist. Same thing with Girardi. Same thing with a lot of these lawyers where it comes time to pay the piper and it all explodes on you and your life is basically over because of the decisions you made purely out of greed and for money.
They weren't enough. And not only did he have huge fees from those particular cases, but he also stole money from clients as well. Your Honor, if I look at the unbroken chain that I'm talking about here, of these thefts that went on, they start in 2011. And every single year from 2011 to 2021, he stole money from clients. It is an unbroken chain.
Which is like one of the most despicable things you can do, because it's a different type of relationship. Clients literally trust you. They choose you over thousands of lawyers they can pick. So stealing money from your clients while you're also advising them on major life decisions is just absolutely despicable.
Because even though he was making 6 and sometimes 7 figures of legitimate income in his law practice, it was not enough to sustain the lifestyle that he had and the debts that he had. Even though he was borrowing millions of dollars from Palmetto State Bank, from his buddy Russell Lafitte, borrowing close to $1 million from his law partner, borrowing hundreds of thousands of dollars from his father, borrowing hundreds of thousands of dollars from Russell Lafitte's father, having Russell Lafitte loan him close to $1 million from the Plyler money, for which he had Russell appointed conservator. It still wasn't enough. It wasn't enough to keep Alec Murdaugh's head above water. And it couldn't stop. It couldn't stop. I've detailed in the filing, Your Honor, generally familiar with the state grand jury evidence of the 4 manners in which he was stealing money, including from his own family and his law firm. And he'd been doing that for a long time. But one thing happened that caused the slow burn to finally heat up. And that was the boat case in February of 2019.
The boat case where his son got a BUI and it was a deathly crash. Again, we've done other videos on it, but that's what he's referencing.
I've done a lot of white-collar crime, and like every Ponzi scheme, theoretically a Ponzi can last forever as long as there's new money. But the second that money stops or slows down, it's never going to crash and burn. And that is what the boat case meant here. That is what the boat case meant here. And so what we see after the boat case is we see a huge uptick in the amount of money that he is stealing. And the biggest one of that is the Satterfields. And that was different because he's actually the defendant in that particular case. He's not the plaintiff's attorney there.
That's one of the wildest cases I've ever heard in my life. He basically, his housekeeper fell down his stairs. He talks to her family to sue him and get his insurance, and then ends up stealing part of the proceeds. I did a whole in-depth video, deep dive on that. I really encourage you to check it out. It is wild and mind-boggling for me. I've never seen anything like it.
And what he does is conspire with his buddy, Corey Fleming, to get a recovery against his own insurance company for her fall at his house. And then has Corey Fleming write the check out to the fake forge account, $2.9 million. And unlike prior to the boat case, where he's able to pull off a sleight of hand of stealing money from clients in plain sight with stuff on the disbursement forms. And
Brittany B., I really encourage you to dig into this one. It is the wildest story, I think, of all the ones that we've covered, which is saying something.
the sheets that they're signing, because at the same time, he's handing them a huge check of life-changing money, and they're shaking his hand as they walk out the door. Here, with the Satterfields, after the boat case, he takes it all. He takes every dime. Every dime. What does that mean? Well, one thing it means is that he doesn't have an umbrella policy anymore. And so the boat case becomes very significant because the plaintiffs in the boat case made it very clear that this was not just about recovering from an insurance company or recovering from the deep pockets of the convenience store or the bar. The plaintiffs wanted a specific personal recovery from Alec Murdaugh because they believed, like everyone, that he had a lot of money. And it was the principle of the thing that they wanted him to pay, personally, that there was going to be any settlement. And as that time went on, the boat case plaintiffs made it very clear to Alec Murdaugh's civil attorneys that we want a personal recovery from Alec Murdaugh. And they finally, his attorneys finally tell them, and they say, he doesn't have any money. And they're credulous, they don't believe that, because like everyone, they believe he's a very wealthy. And they file a motion to compel, to disclose his accounts, to disclose his finances, to disclose all of that. And that hearing is initially set for May of 2021, but it gets continued because Mr. Murdaugh's attorney, John Tiller, who's of course deceased now, is having medical treatments. What else is going on at this time? We're in now the spring of 2021. Well, state grand jury subpoenas are being issued as well about the boat case out in Hampton and Collin counties. And what else is going on at this particular time? Alec Murdaugh has an opportunity for a big recovery in a case he has with Chris Wilson. And he actually argues and agrees to get the defendants, who were a big automotive company, and he gets them to agree to what seemed like a really good move at the time. He gets them to say he's going to waive punitive damages if they waive the right to appeal. So that it's going to be bench tried, and so whatever decision is made, bench tried on just damages, then that money's going to be instantly available. That might seem like a good strategic move, but the reality is that Alec Murdaugh needs that money right now. Because the way the law firm works is that you don't get your bonus until the end of the year. And other than that, you just get $125,000.
This is amazing. This is one of the ways he got caught, because people kept asking for money and he kept dodging it.
spread out over the course of a year. For a person that the second he gets an infusion of cash, high six figures, it's gone within 2 months. So that case happens. The judge issues his ruling, and ultimately it's a pretty good recovery, and there's $792,000 in fees for Mr. Murdaugh. But what he does is he convinces his co-counsel in that case to write those fees directly to him instead of writing it to the firm. And why is that? So that he can get that money right away and bypass the firm where it's supposed to go. And so he does that, $750,000, and it's gone within a very, very short period of time. In May of 2021, though, his staff, Mr. Murdaugh's staff, becomes suspicious because they get the expense check and they don't have the fee check. And they call up the other attorney's office and they say, "Where's the fees?" And initially, apparently, he was like, "Well, we can't get to Ellie." And then they're trying to figure it out and they can't get a satisfactory answer. And they go up and talk to financial staff and they're trying to get a straight answer and they can't get a straight answer. And one of the attorneys calls that other attorney and they can't seem to figure it out. Where are these fees? We're at $792,000 in fees. He's already got it. He's already spent it. He doesn't have the means to pay it back. So what happens on June 10th? All of this is finally coming to a head. That morning, PMPED staffer comes in the office at the direction of the partners and says, "Alec, I need an answer today. Where is that money? I need an answer today." And Alec is in his office working on the boat case because that hearing is scheduled for June 10th. And Judge Hall has made it very clear there are going to be no more continuances. And that's going to expose everything as well. And the only thing that stops the conversation about "I need an answer right now" is that Alec, unfortunately, gets a call that Mr. Randolph had gone to the hospital with a very poor prognosis. His father, who repeatedly had loaned him hundreds of thousands of dollars when he needed it. All of those are happening on this very day. It's a day of reckoning for him. The very day that Maggie and Paul were murdered. And what happens in the wake of that? What happens is the exact opposite happens. Everybody immediately rallies to his aid. Immediately that hearing is canceled. It's not even rescheduled anytime soon. The PMPED people would be, the last thing they're worried about is where these fees are. They don't care about that anymore. They're all rallying to his aid. All of the things that were about to happen stop. And what does he do in the interim? One of the first thing he does, at least business-wise, is get more money from one of his law partners, get more money from Russell Fee from Howman State Bank in order to send enough money to Chris Wilson, and Chris Wilson will then send it to PMPED and say, "Yeah, those fees will go. Everything's cool." He covers his tracks.
I mean, you look at all of it's like when you hide a ball under one of those cups and then you move it all around. That's what Alec Murdaugh was doing to try to keep this afloat.
And that would have never happened if it wasn't for the deaths of Maggie and Paul. It would have never happened. And the only thing that changed was that in September, a PMPED staffer happened to find a copy of the check that was written from the other lawyer, directly made out to Elk. And she knew right then
It's wild
that he had been lying about it. And she takes it to another staffer, and that triggered another staffer to think about some other forged checks that had been made out that didn't seem quite right. And they go look at those checks, and then they run it through the system.
Here's an issue. You hear this and you basically can understand, like, you can almost see this guy being guilty of anything at this point if he's willing to do all of this. And to me, that's what makes this difficult to make a call for the judge. And Rebel Duck asked the ultimate question: will these past crimes become part of the trial? That's exactly what the prosecutor's trying to do here, is get the judge to allow him to argue all of this to show motive. But it is so prejudicial. And does it actually go to prove that he committed these murders? And Miss Anonymous said his strategy is to admit one crime to cover up another. That doesn't really make much sense. This is exactly what the defense argues. So you're saying he had all these financial crimes, so he commits another crime because he doesn't want to get caught for this crime? Because there's no evidence that they knew about this, and there's no evidence that he was going to get finances like a life insurance policy from these murders. So does that really make sense? And I'll spoil the ending for you. The judge did not make a decision yet. He's going to reserve ruling, but there's still a couple more minutes. But you're just seeing the prosecutor go in on Alex Murdaugh, and you hear how horrible of a guy he is. And if the jury hears all of this, can they really acquit based on any crime? And that's the issue, because the answer is no. If the answer is all of these crimes make me think he's guilty of everything, then this should not come in this case. But if it makes me think, oh, this is the reason he committed the murders, then it should come in because it's more probative than prejudicial.
And all of a sudden, all the forged checks start popping. And they go and take it to the partners, and they're like, "Oh my God, he's been stealing from us. He's been stealing from clients." And they eventually confront him, and he resigns. That's September 3rd. September 4th, his best friend, who he had convinced to send back those fees to PMPED, but to cover $192,000 with his own money that Alec couldn't borrow enough to pay, is trying to get a hold of him and finally gets to meet with him on the doorstep or on the front porch of Alec's mother's house. And Alec confesses to him that he's been using pills and he's been stealing, and he doesn't have $192,000. All that accountability is starting to crash down on Alec again. And what happens? Within a couple of hours of that conversation with his best friend confronting him about the $192,000, Alec is the victim on the side of the road. And instantly everybody rallies to his aid again. Accountability is coming on him, and suddenly there's a gunshot and he's a victim again. And everybody rushes to his aid again, except this time it doesn't take long for people to figure out that something's not right. But the symmetry there.
And this is the fake suicide attempt with your drug dealer twist to the case. If you had that one on your bingo card, check it off. We also did a video breaking this down. It is wild. You cannot make up the stuff that happened in the Alec. I don't know. Again, I've heard people call him Alec Murdaugh, Alex Murdaugh, Murdaugh. So doing my best, all these different pronunciations just kind of fuse together when I say it. But this is an incredibly wild case. And that's not hyperbole. Literally, I've never seen anything like this. All of the twists and turns. And the prosecutor's going through a lot of them. Stealing from clients, fake cases, suing himself and taking the money, fake corporations he sets up to send the money to, stealing, robbing Peter to pay Paul, fake suicide attempts, trying to get life insurance policies, not knowing the clauses in his life insurance policy. He doesn't even have to fake the suicide attempt. It's wild.
It's very, very telling. Your Honor, this is an unbroken chain of financial crimes that highlight what has happened here. This is a white-collar case that culminated in murders. And we've cited a number of cases in here of very, very similar circumstances in which courts have admitted evidence of motive just like this. And I would actually point to one case that we cited, and this is the Siegel case. And this was written, I believe, by Judge Traxler on 4th Circuit. And there's a number of cases that we cited in our brief.
The defense actually has a pretty good response to this, and that is a lot of those financial cases, yes, the financial stuff was able to come in the murder, but that's because there was going to be financial gain because of the murder, like somebody asked earlier with a life insurance policy, or that the people that were murdered were proven to have been witnesses of the financial crimes, and they were killed because they knew of the financial crimes and was going to rat out the defendant. Those were some of the reasons why the financial information was allowed in those cases. Very different than here, when it's just a bunch of bad acts he's been accused of, none of which he's been convicted of so far, right? Because prior felony convictions, those can come in. The details probably not so much, but sometimes the crimes of moral turpitude can come in. But regardless, this is very different than that, and the judge has a very important decision to make here.
And this is a quote from that particular case. Because Siegel had been defrauding multiple victims for the last at least 20 years and had never taken such extreme action, it is particularly important for the government to be able to explain to the jury why it was suddenly necessary for Siegel to resort to murder. This is not propensity evidence. Evidence of all this fraud and abuse of his law license is not propensity evidence. It doesn't show that he's more likely to engage in fraud, because murder is a much different thing than fraud. But what it does show is what may be the most important fact in this entire case.
This argument I just can't get behind with this. It's like, oh, this isn't a propensity argument. He's not has a higher propensity to commit murder because he's a fraud and his entire life is fraud. But it's like, come on, you just gave a 20-minute argument about all the horrible stuff this guy did, and not even in the gory details. A juror is going to hate him if you're able to get into all that.
And that is why this particular individual would murder his own wife and son. And the answer is because it allowed him to escape the accountability that was coming upon him that he never had to deal with in his entire life. Never had to deal with it in his entire life. And it worked. It worked. And if it wasn't for that check showing up in September, it might be still working to this day. I think the case law is clear, Your Honor, that this is admissible evidence in this particular case because of how important motive.
So very interesting. And again, we've gone through a lot of what the defense argues already. But the judge ends up reserving ruling on this one. And then there is a third motion to not have Alec Murdaugh shackled during the trial, which is agreed to basically. So he's not going to be shackled during the trial. It seems like the trial is going to be televised, which is going to be very interesting to watch. But at the very end, something very interesting happens. And John O'Rourke already kind of blew my surprise here. But when we talk about this family, the family name, how well known they are, how people know about them. Well, just to illustrate it, this happened at the end of the hearing the other day. The judge actually had to point this out, which just think about this and how wild this is. This is the courtroom where this case could potentially be tried, where all the jurors are going to sit, where all the witnesses and family members potentially, and law enforcement officers and lawyers that he worked with are going to come. And what's hanging up in there? I'm going to slow it down because sometimes the judge is a little harder to hear.
Survived on the 23rd. Survived. The 23rd. They were advising me the office may be closed, but that's not stop us from working. This,
He basically said the 23rd they're going to be working.
this on the horizon.
All right, very good. One additional issue. And been pointed out that Mr. Murdaugh's grandfather's portrait hangs in the courtroom.
Alex Murdaugh's grandfather's portrait hangs in the courtroom. They don't just hang anybody's picture there, right? His grandfather either paid for a wing in that courthouse, which is a little scary if you're going to go up against somebody with that name. Just think about what was handed to this guy, right? I mean, you had it, dude. Just be a decent human being and a decent lawyer. The cases are going to come in. The clients are going to trust you. The judges are going to trust you. The prosecutors are going to trust you. You have lineage here, deep rooted in South Carolina. Now, I don't know about his, dad or grandfather, or whatever. They could have been scumbags too, or frauds too. I don't know, but I'm just saying, like, if they're hanging your grandfather's picture up in the courtroom, you're starting out not one step ahead, but 1,000 steps ahead. And just don't steal money from your clients. Just don't be a jerk. Just don't kill people, right? I mean, it's just wild at how this spun out of control, but it is wild to me that they actually have to bring this up and everybody agrees to take the picture down or leave it up to the judge's discretion. But it is wild to me to think about, like, just to be sitting in that room and being like, yeah, my grandpa, Papa's picture is hanging up in the back of the courtroom that I'm being tried for killing the next generation of this Murdaugh family. I mean, it is wild for me to think about. So that's probably going to come down. Murdaugh's not going to have shackles on. They are going to get more information on that expert, as Murdaugh's lawyers like to call him, and we will see if this other bad acts or other crimes evidence is going to come in. So it is wild, wild, wild to me. Anne Marie asked where the housekeeper case is. The housekeeper case, the fake suicide case, all of those are on our playlist on YouTube. Lawyer, there's an Alex Murdaugh case playlist. So scroll down until you see it. Check out all the videos on there. You will not be disappointed. This is a wild ride. There are wild details throughout this story. I really can't understand it. So when a lot of you said you were interested and wanted to hear about this hearing, I was down for it because this case interests me so much. KWNY Upstate, don't commit crimes that sound like your name. You will be the suspect in a murder. Yeah, I mean, it's really, really crazy to me. Somebody said, Tragos Law, maybe your picture will be up in a courtroom one day. Highly doubt it. Highly doubt it. Oh, the walls of YouTube. Sorry, the walls of YouTube. More likely than a courthouse. But I'm just saying, I mean, the extent to which this family is deep-rooted, I never heard of them before this, right? I'm not from South Carolina, but I'm starting to get the picture because I know the families that are up in the courtrooms here. And it's wild. It's wild to have this multi-generational firm here. So hit that like button, please. Subscribe if you haven't already, because we will be following this case, and it's 5 weeks till trial. So the trial is coming soon. We will absolutely be covering it on this channel. So make sure you hit that like button, subscribe, and hit the reminder bell. But before we go, as promised, I want to share my screen here one more time to show you a YouTube stud here, an up-and-comer that has asked to get to 100,000 subscribers. Let's refresh here. He's up to 25,000 subscribers. So go hit that subscribe button also for Cracking the Box. And your friend, Captain Jack Sparrow, has a little message for you when you get to that page. So check out that video as well. And, you know, provide a little joy for a guy that's had a couple open heart surgeries in his young life and is dealing with it and has a tough road ahead of him. So to brighten the day just a little bit more for him, go hit that subscribe button and get him up there. Get him up towards 100K. That's what he's going for. So I appreciate all you guys joining us for the video today. Hit that like button on your way out. Comment any questions you have about this case or what other cases you're watching. So I appreciate all of you. As always, until next time, I'm out of here.